Welcome to a brief webinar today on deeds of trust and what you need to know. You'd be surprised how much confusion there can be sometimes around a simple instrument in our estimation, the deed of trust. And so this is just meant to be a basic primer on deeds of trust, things you should look out for, be prepared for, and just some general background on deeds of trust as instruments relating to property and security. So, looking ahead here, some of the topics that we will be looking at, the definition, of course, who exactly the parties to deeds of trust are is critical for us to understand. Pitfalls that we often see, and then outcomes as we over time either foreclose or on the deed of trust or record a full reconveyance. So, starting here, what is a deed of trust? Here's a definition from the Washington Real Property Desk Book, put out by the Washington State Bar Association. And I'll just read this through briefly, and then I'm going to come back and highlight a few of the phrases and terms here that are of particular importance. So the deed of trust is a species of mortgage, and specifically a three-party mortgage, with a power of sale vested in the trustee. The grantor conveys the property to a trustee in trust for the beneficiary to secure an obligation owed by the grantor and or borrower to the beneficiary. This deed of trust creates a lien in favor of the beneficiary. So it's a lot to take in, as most of these kinds of definitions can be. So let's kind of break it down here. So the first thing is the word mortgage. I'll get into this in a little more detail in a second, but a mortgage, people think in mortgage states, it's pretty straightforward. People realize that when they take out, for example, on a home purchase, a loan, that there is a mortgage associated with their home. And whether they understand what that means or not, we'll get into in a second. But it functions, a deed of trust functions in very much the same way as far as securing the loan with the property itself. So mortgage is a key word. A three-party mortgage is important, and we'll look at that in a second, the difference between a two-party mortgage system and a three-party deed of trust system. The power of sale vested in the trustee. There's some confusion over the role of the trustee, but power of sale is an important turn of phrase that we're going to look at here. That is what the trustee is granted via the deed of trust, the power of sale. The grantor conveys the property of trustee in trust for the beneficiary. Okay, so we will look at the grantor conveying the property, and that is in quotes, to a trustee in trust for the beneficiary. The next thing, an obligation. There is some debt, underlying debt or obligation that is being secured. And then the last thing is very consistent with that obligation then here is that it creates a lien in favor of the beneficiary on the property. Okay, so that's, again, a lot to take in, but mortgage, it's like a mortgage. There's three parties. The trustee is granted a power of sale. It secures an obligation and functions like a lien. Those are kind of 5 key takeaways from this definition of a deed of trust. Okay, so the parties. I mentioned a bit ago then that in a mortgage state, you have two parties, right? The mortgagor, who is the borrower on a loan, and a mortgagee, the lender. And so very simple then, where someone takes out, for example, a home loan, and they are the borrower, and the mortgagee then functions as the role in the role of the trustee in a deed of trust system, right? They will record a deed of trust, or in this case, a mortgage on the property. And when the time comes to, for example, if it's fully paid off, the debt is fully paid off, they will then reconvey whatever power they were granted under the mortgage back to the borrower, the homeowner, in the two-party system. Three-party system under a deed of trust, there is still the borrower and lender, although here we use the terms grantor and beneficiary. And the trustee is the third party. And they have a very limited role here then, in that they are the party that is granted the power of sale for the property. In the event of a default, they have the power of sale at the upon satisfaction of the loan or the debt or the obligation. They will reconvey whatever right into the title that they had as trustee back to the borrower, grantor, homeowner. So again, using the most common example where we see deeds of trust, a home purchase. So on a home loan, the grantor borrower owns the property in fee simple. There is a lot of confusion sometimes for people when they look at the language of a deed of trust and they see that the trustee has some right in title, or they're holding title, that the grantor is unclear as to whether they actually own the property. They do. If you have bought a residential property with secured with a loan that's secured with a deed of trust, you own the property, but you still owe on this loan or note. And so what you do is you grant the beneficiary, the lender, a deed of trust that secures that loan or note with the property. The lender then holds that loan or note secured by the deed of trust as a first position lien on the property. So not too unfamiliar then as far as what the relationship is there with borrower and lender. Again, the trustee then is a third party who under the deed of trust is granted the power of sale of the property over the entire term of the loan. And whether it results in a non-judicial foreclosure or a full reconveyance, the trustee will be the one who will pursue either of those options. So, let me move this here. A few of the things that you want to keep in mind then as you consider a deed of trust as an instrument here. You want to make sure that you review the title report, that you understand that this deed of trust is a cloud on title. It is recorded. It is not a deed in the sense of a deed of conveyance, as we think of a statutory warranty deed or a bargain and sale deed or a quitclaim deed. But it grants, there is a conveyance of sorts in that it grants this power of sale to the trustee to secure the debt by the borrower. So we want to make sure we review the title report. We see if there's any other clouds on title. If you're pursuing traditional financing with a bank, they're going to insist that they're in first position securing their loan on the property. So it's good to review a title report, among other things, to just see, what else is recorded on title. The other important piece of the title report that you want to make sure is accurate in any deed of trust is the legal description. It is critical that what is being secured is what is intended to be secured. In other words, from the point of view of the lender, the beneficiary, If there is any kind of question about the deed of trust, the only power the trustee has is over that property as it is legally described in the deed of trust. And so if the legal description is insufficient, if it's incomplete, if there is some sort of mistake, that could have legal ramifications that could land you in litigation. So you want to make sure that the legal description in the deed of trust is accurate and complete, and the intention of the parties is to secure the loan with the property as described. Third little pitfall here that I've included was to ensure that the secured obligation is accurately referenced. Just to make sure that we know what exactly is the obligation that is being secured, so that whether there is a default on said obligation, or if there is some satisfaction of the obligation where the final payment has been made, that the parties are clear that the obligation has been met or has been defaulted on. So just to be accurate with that piece of it as well. So one of the outcomes is if there is a default on the underlying obligation, or in our example, on the home loan, what the trustee will do is issue a notice of trustee sale. That will include, among other things, the time, date, and place of a public auction. It will identify the instruments at issue, so the deed of trust, issued or recorded on this date. It will include the legal description of the property. Again, what is going to be going up for sale by the trustee. And then at the conclusion of the trustee's sale, the trustee will issue a trustee's deed. And this is a deed of conveyance, a trustee's deed that conveys all right, title, and interest in the property to the purchaser. Now, much happier outcome would be a full reconveyance. So upon satisfaction of the debt, the trustee, having received a written request from the beneficiary, reconveys all right, title, and interest held by the trustee in and to the property described in the deed of trust. So the way that this works, upon satisfaction of the debt, the beneficiary, so the lender, will submit in writing to the trustee a request for a full reconveyance, saying debt has been satisfied, the obligation has been satisfied, please reconvey the property. At which point the trustee will do so, and that reconveyance gets recorded as well. And so it is noticed to the world that the deed of trust, which had been recorded previously, has been removed from title and is no longer a cloud on title and has been reconveyed to the owner. So that's the gist of it. I think, as I said earlier, the biggest confusion about this, and there are all sorts of contexts where we see deeds of trust, a mortgage type loan, sometimes there's seller financing. So you sell a property and you need to secure the payments over time on the promissory note or on the loan that you have made to the purchaser. And so you will record a deed of trust for that amount. Refinances, lines of credit, any sort of promissory note or debt that is a payment obligation that can be secured on real property, we use the deed of trust here in Washington. And so all those kinds of contexts, you may find yourself on either side of it, whether as a borrower or a lender, or in our terminology, a grantor or a beneficiary. But it is, I think, the biggest misconception we get is that confusion around the word deed, as far as it doesn't deed title by conveying ownership to the trustee, it grants the trustee the power of sale. And to understand then beyond the use of the terminology that the instrument is a security instrument on the real property, that the trustee is empowered to act over the term of the loan, either to foreclose or to fully reconvey. And those are kind of the primary outcomes here. So I appreciate you listening and participating in today's webinar. If you have any questions, please feel free to reach out to our business and real estate group here at Beresford Booth. There's my email address and our general phone number, and we'll be happy to help you or answer any questions you may have. Thanks very much.